Good morning, friends. In our earlier session, we have covered from section 1 to section 5, which pertains to the definition part of some important terminology of the IBC. Today, we shall be discussing the relevant portion of the CIRP, which are contained in the IBC from section 6 to section 3. To have an overview of this CIRP, we have narrated the sections which the students are supposed to remember. It is not necessary to remember the subsection or subclass of the sections, but if you are remembering the main sections, then it will be more attractive answer at the time of the evaluation. So let us have at a glance of these sections. Section 6, it pertains to the persons who may initiate CIRP. Then section 7, CIRP by financial creditor. Section 8 and 9 relates to the CIRP by the operational creditor. And section 10 relates to the CIRP by the corporate applicant itself. Then section 10A was inserted by way of an amendment. It provides the suspension of the initiation of the CIRP that was introduced during this pandemic situation. Section 11 deals with the persons not entitled to make the applications. Similarly, section 11A was inserted by way of an amendment in the IBC. Then section 12 provides the time limit. Section 12A, it deals with the withdrawal of the application admitted under section 7, 9 or 10. Section 13, 14 and 15 relates to the declaration of moratorium, public announcement, moratorium and public announcement. Then appointment and tenure of IRP are contained with section 16, management of affairs of the corporate debtor. What are the duties of the IRP under section 18? Then the corporate officials of the corporate debtor are supposed to extend cooperation to the IRP that are contained in section 19. Section 20 deals with the operation of corporate debtor as a going concern. When the IRP is taking charge of the corporate debtor, it has to run as a going concern. Most important section is the section 21 that deals with the committee of directors, creditors. Then appointment of the resolution professional, section 22. Section 24, meeting of the committee of creditors and duties of the resolution professional, like that. And similarly, rest of the provisions are contained section 27 to 32A that relates to the submission of the preparation of the information memorandum and who are the persons who are not eligible to be the resolution applicant, like that. To have an overview of the CIRP process, as we have discussed in our earlier session, that the focal point is the default. Whenever a default occurs, the initiation of the CIRP may start from that focal point. When a default occurs, then the financial creditor or the operational creditor or the company itself may initiate the process of CIRP and file an application to the adjudicating authority. For corporate persons, the adjudicating authority is the NCLT. NCLT may either accept the application or reject the application. If it is accepted by the adjudicating authority, the moment or the date when the application has been accepted, insolvency commencement date starts. From that date, the declaration of moratorium is declared by the adjudicating authority, and simultaneously the appointment of IRP is made. Public announcement is made by the IRP. IRP collects the information from the creditors and constitute a committee of creditors. Thereafter, a meeting is convened by the IRP of the committee of creditors, and in that COC, the approval and appointment of the resolution professional is decided whether the same IRP is to be continued, and if the COC desires to appoint another person, they may choose so, and another person, another insolvency professional may be appointed as an RP. Whenever the IRP or RP is appointed, he has to look after the management of the affairs of the corporate debtor. He prepares the information memorandum, circulates it through the newspapers and the website of the corporate debtor, and the link provided by the IBVI at its portal. Expression of interest is invited by the resolution applicants. Whosoever is interested in taking care of the affairs of the corporate debtor may submit the resolution plan. And if the resolution plan is approved by the committee of creditors, it is submitted by the RP to the NCLT. The NCLT, if approves that plan, then the resolution applicant may take over that company. The resolution plan may have the provision of either the merger or takeover. And if the plan is rejected, the NCLT may order for the closure or winding up of the company. It is a whole of the process, which we have in a nutshell described as a one-pager on this screen. Now the first section of the CIRP, that is the section 6, which provides that where a corporate debtor commits a default, then a financial creditor, an operational creditor, or the corporate debtor itself may initiate the CIRP proceedings. CIRP may be initiated by filing an application with the adjudicating authority, that is the NCLT for the corporate debtor, when a default has occurred, by a financial creditor itself, jointly by the financial creditor or any other person on behalf of the financial creditor, as may be notified by the central government. Let us take an example that a company has availed term loan or working capital finance from a bank, or say from 2-3 banks, and from one bank he has defaulted in repaying the dues of that a particular bank. The bank is considered as a financial creditor. That particular bank may initiate the CIRP proceedings, or that particular bank in association with the other banks also can jointly file application for initiation of the CIRP. That is why it has been mentioned that a financial creditor either by itself or jointly with other financial creditors may initiate the CIRP proceedings. The government has, in February 2019, circulated a notification that the following persons may file an application for initiating CIRP against a corporate debtor before the adjudicating authority. Who are they? They may be the guardian, an executor or administrator of an estate of a financial creditor, a trustee, including a debenture trustee, and a person duly authorized by the board of directors of a company. Financial creditors, as referred to in section 21, subsection 6A, subclass A and B. First proviso to the section 7, subsection 1, which provides that it may be filed jointly by not less than 100 of such creditors in the same class, or not less than 10% of the total number of such creditors in the same class, whichever is less. Then what section 21 subsection 6A describes about? It provides that where a financial debt is in the form of securities or deposits, is owed to a class of creditors exceeding the number as may be specified. Similarly, the LOTs under the real estate project, which is described in section 7(1), second proviso of section 7, subsection 1, then not less than 100 of such LOTs under the same real estate project, or not less than 10% of total number of such LOTs under the same real estate project, whichever is less. Now here the words used are same real estate project. A builder might be having 4 or 5 real estate projects. For example, in Bombay, one builder is having 5 real estate projects, namely A, B, C, D, and E. Let us take an example of project A. In project A, whatever the commitment has been given by the builder that he will provide the possession of the flat on a certain date, and the builder is not providing the possession of that flat, what he has committed to the LOTs, then only the LOTs of project A, that is 100 of such LOTs, or not less than 10% of the total number of such LOTs, only from project A, whichever is less of both these two lines, can initiate the CIRP against that builder. They cannot be clubbed with the project A or project B or project C, because these are the separate projects. So the wordings used in the second proviso to section 7 subsection 1 is under the same real estate project. How the application will be moved? What is the format? That is prescribed in Rule 4 of the Insolvency and Bankruptcy Application to Adjudicating Authority Rules 2016. Rules are framed by the central government. Regulations are framed by the IBBI. So this Rule 4 provides that a financial creditor, either by itself or jointly, shall make an application for initiation of CIRP in form number 1. This form is provided in the Rules 2016. This Rule 4, Subrule 2 provides that where the applicant is an assignee or transferee of a financial contract, the application shall be accompanied with a copy of assignment or transfer agreement. So along with the form 1, one has to attach the form if the financial rights have been assigned to some other person. Then applicant shall serve a copy of the application to the registered office of the corporate debtor and to the board. Board means the IBBI, by registered post or speed post, or by hand or by electronic means, before filing the adjudicating authority. So before filing of the application before the NCLT, one should serve a notice on the corporate debtor's registered office, as well as a copy of that notice to the IBPI office, and the form prescribed is Form 1. And if there was an assignment, the financial creditor has to submit the copy of that assignment also. Then one may ask that what is the filing fees? For the filing fees, the financial creditor, it is 25,000. And when the application is initiated by the corporate debtor itself, it is also 25,000. But when the application is moved by the operational creditor, it is only 2,000. So the students may remember 25,000 and 2,000. 2,000 is for initiation of CARP by operational creditor, and for rest of the two categories, that is the financial creditor and the corporate debtor itself, the filing fees is 25,000. Section 7, subsection 3 provides that along with the application, the following documents has to be attached. What are they? Number 1 is record of the default recorded with the information utility. The focal point, the starting point is the default. So when the default has occurred, it has to be provided with the documents. Then the name of the resolution professional proposed to act as an IRP. So financial creditor has to propose a name of the IRP. One may ask that where we will find the name of the IRP. For that name or panel of the IRPs are being maintained by the IBPI, and for by every 6 months, the panel is reviewed or revised. So whosoever is having the name of the IRP and having the AFA, that person may be selected and the name of that person may be proposed, or any other information as may be specified by the IBPI. That these all has to be enclosed along with the Form 1. Record or evidence of default by financial creditor, Regulation 2A. It provides that a certified copy of the entries in the relevant account in the banker's books. A financial creditor who is initiating a CIRP, then he has to submit a statement of account that this amount was due to be paid by the corporate debtor, which he has defaulted, and in spite of the repeated reminders that the corporate debtor has not paid. So this type of evidence, or say a statement of account, has to be submitted along with Form A. This evidence is admissible under the Bankers Books Evidence Act 1891. Or if the financial creditor has already obtained a decree from any competent court or tribunal, the copy of that court or tribunal may be attached along with the Form 1. Then ascertainment of existence of default by the adjudicating authority. Once the financial creditor has submitted the application in Form 1, now the adjudicating authority has to decide by scrutinizing the application that whether the default has actually occurred or not. The whole of the process is to be completed by the NCLT within 14 days of the receipt of the application from the financial creditor, and the adjudicating authority has to ascertain that the existence of default from the records of an information utility or on the basis of the other evidence like statement of accounts, which is permissible under the Bankers Books Evidence Act furnished by the financial creditor. If the adjudicating authority has not ascertained the existence of default and passed an order within such time, it shall record its reasons in writing for the same. Now there are two options with the adjudicating authority. Either to admit the application filed by the financial creditor, or reject the application filed by the financial creditor. When the application is admitted, Section 7, Subsection 5, Subclause A. A default has occurred and the application is complete and there is no disciplinary proceedings pending against the proposed resolution professional, it may order admit such application. So what are the 2 points? Number one, that application is complete along with all the required enclosures and no disciplinary proceedings are pending against the resolution professional. If these two things are not in compliance, the adjudicating authority may reject the application. But before rejecting the application, the adjudicating authority may ask the financial creditor to rectify that defect. Now the commencement of the CIRP. When the commencement will take place, the CIRP commencement date will be the date of admission of the application by the NCLT. The moment the NCLT accepts the application, the commencement of CIRP starts from that date, not from the date when the application was filed by the financial creditor. Why this date is important? Because when we are counting the total period of 180 days, from this date, we have to calculate the 180 days. So this date is important, that is the commencement of the CIRP. The adjudicate authority shall communicate the order of admission of the application. When the application has been accepted, it shall communicate to the financial creditor as well as to the corporate debtor. And when the application is rejected, the adjudicating authority will inform only to the financial creditor. Now, come to the insolvency resolution by the operational creditor. That is the Section 8 and Section 9 also. Section 8 and 9 deals with the CIRP relating to the operational creditor. This section provides that an operational creditor may, on the occurrence of a default, deliver a demand notice of unpaid operational debtor, copy of an invoice demanding payment of the amount involved in the default to the corporate debtor in such form and manner as prescribed in Rule 5 of the Insolvency and Bankruptcy Application to the Adjudicating Authority Rules 2016. As we have earlier discussed, that who is the operational creditor? The person who has supplied goods or services to the corporate debtor, he is called the operational creditor. Let us take an example that a person has supplied goods to a corporate debtor, and whatever the terms and conditions mentioned on the invoice that the company has to pay, means the debtor has to pay the invoice amount up to certain time limit, and in spite of the repeated reminders, if the corporate debtor is not paying the dues, then the operational creditor may initiate for the CIRP against that corporate debtor. It means the occurrence of the default, means in spite of the repeated reminders to pay off the dues, the company is not paying, it means the occurrence of default. So what recourse is available with the operational creditor? Number one, default has occurred, then he will deliver a demand notice in a prescribed form. So before initiation of the CIRP, the operational creditor has to serve a demand notice along with an invoice to demand for the payment of the amount involved in that invoice. Rule 5 of this application to the Adjudicating Authority Rules 2016 provides that operational creditor shall deliver to the corporate debtor the following documents: demand notice in form number 3 or copy of an invoice attached with a notice in form 4, demand notice or the copy of an invoice demanding payment may be delivered to the corporate debtor at its registered office by hand, registered post or speed post or email to the whole-time director or to the designated key managerial persons of the corporate debtor. And copy of the demand notice or invoice demanding payment shall also be filed with the information utility to build up a record. Section 8, subsection 2 provides that corporate debtor shall, within a period of 10 days of the receipt of the demand notice or copy of the invoice, bring to the notice of the operational creditor that there is a existence of dispute or the payment of unpaid operational debt by sending an attested copy of the record of electronic transfer of the unpaid amount from the bank, or by sending an attested copy of the record that the operational creditor has encashed a check. So that the whole of the scenario is that when the operational creditor has served a demand notice on the corporate debtor, what recourse is available with the corporate debtor? The corporate debtor will either may raise a question that there is already a dispute between the corporate debtor and the creditor. What may be the dispute? Dispute may be relating to the quality, quantity of the goods or the quality of the services provided by the creditor, or the corporate debtor may take a plea that we have already made the payment, and in support of this his statement, he may submit a proof that by certain check number or certain electronic transfer, we have already made the payment. So there is no question of raising again and again this amount. So recourse is available with the corporate debtor. And this reply has to be given by the corporate debtor, and the time limit has been prescribed is within 10 days of receipt of such demand notice from the operational creditor. If this time period of 10 days has elapsed, then when the operational creditor has received no notice of existence of dispute or payment of unpaid operational debt, then the operational creditor may file the application for initiation of the CEL. Let us have some judicial pronouncement of Section 8, Subsection 2. In Mashreq Bank Limited, the Supreme Court held that authorized agent or a lawyer acting on behalf of a client can issue a demand notice under Section 8, Subsection 2 of the IBC. So that it is not necessary that the operational creditor may suo motu serve a notice, but he may ask this task to his lawyer, and if the lawyer is issuing a demand notice to the corporate debtor, it is sufficient that the Supreme Court has opined in this case. In the next case, the Mobilox Innovations Private Limited, the Supreme Court opined that the notice of dispute issued by the corporate debtor must bring to the notice of the operational creditor of the existence of dispute or the fact that a suit or arbitration proceedings relating to a dispute is pending between the parties. What is important is that dispute must predate the receipt of the demand notice. What it shows that when the operational creditor is raising a demand notice, And after serving of the demand notice, the corporate debtor takes a plea that now there was a question of the quality of the services or the quantity or quality of the product was not good. That will not be accepted. If he is having a question relating to the quality or supply or quantity or any other dispute relating to that product or services, that dispute should have been prior to the service of that notice. So the Supreme Court has opined that what is important is that the dispute must predate the receipt of the demand notice. Challenge of the arbitration award. In this case, again, the Supreme Court has examined that whether challenging an arbitration award under Section 34 of the Arbitration Act can be considered as the existence of dispute or pendency of the arbitration proceedings under Section 8 of the IBC. The court opined that challenging the arbitration award would be sufficient to indicate that the award is disputed, and therefore such pending arbitration proceedings would be considered a pre-existing dispute. Now, the operational part of the Section 9. Section 8 relates to the sending of the demand notice by the operational creditor to the corporate debtor. The corporate debtor is having time limit within 10 days. Within 10 days, if he has not raised any existence of the dispute or that payment has already been made, then after the expiry of this period of 10 days, the operational creditor may file an application before the adjudicating authority for initiation of the CARP. The operational creditor shall file in the prescribed form, and the form is prescribed is form number 5. In that form number 5, he will serve a notice on the registered office of the corporate debtor, and a copy of that notice shall also be electronically filed with the IBBI. One of the students has raised a query that after arbitration, can IBC take place as arbitration award is final? Arbitration means it is a route to settle down the dispute between the parties out of the court. So the arbitrators are appointed by the dissenting parties, and whatever the decision is given by the arbitrator, that decision has to be complied with by both the parties. When the arbitrator has given the award or the matter is still pending with the arbitration, it shows that the matter is disputed one. When the matter is disputed one, it means the operational creditor's right is now turned down because the corporate debtor has already made a reference to the arbitration tribunal. So the Judge Srivastava, are you satisfied with the answer? Yes, please. Now section 9(3). The operational creditor shall, along with the application, furnish a copy of the invoice demanding payment or demand notice. Then this application should be supported by an affidavit, a copy of the certificate from the financial institution maintaining the accounts of the operational creditor, and any copy of the record of available with the information utility or any other proof confirming that the default has been occurred. In the given case, Mashriq Bank Limited versus Shilpi Cable Technologies, the Supreme Court opined that the certificate from the financial institution maintaining accounts of operational creditor is not mandatory for triggering a CIRP of the corporate debtor. The debt and the default can be proved by any other documents as well. So it is not necessary to furnish the certificate from the financial institution. Propose a resolution professional. When the application is being filed by the operational creditor, in that application itself, that operational creditor may propose a name of the resolution professional to act as an IRP. When the application is filed by the operational creditor, then the adjudicating authority, again, the time limit is 14 days. Within 14 days, as we have earlier discussed in the case of section 7, when the application is filed by the financial creditor. Similarly, in the case of application filed by the operational creditor, the time limit available with the adjudicating authority is 14 days. Within 14 days, the NCLT may scrutinize the application submitted by the operational creditor to ascertain whether the application is complete in all respects. Then it may accept or admit the application. And if the application is not complete, it may reject the application. How the application will be assessed as complete? That the adjudicating authority will ascertain that the default was made, no payment was made by the corporate debtor, notice was served by the operational creditor on the corporate debtor, and no disciplinary proceedings are pending against the proposed IRP. And if the adjudicating authority is not satisfied with the application or say it is incomplete, it may reject the application. But before rejecting the application, it may give a sufficient time to the operational creditor to rectify such defect. Again, the CIRP shall commence from the date when the application is admitted by the NCLT. So far, we have discussed section 7, which relates to the initiation of CIRP by financial creditor. Then section 8 and 9, initiation of the CIRP by operational creditor. Now, section 10, the initiation by the CIRP by the corporate applicant, means the corporate debtor itself. A company has availed financial credit from a bank, and due to the reverse economic cycles, that company is not able to pay the dues of the bank. Account has been classified by the lender in their books as non-performing advances. The corporate debtor itself may make an application under Section 10 of the IBC for initiation of CARP with the adjudicating authority. The prescribed form is the Form 6, where it is prescribed. The Form 6 has been prescribed under the rules, the same rules of the insolvency resolution process for the corporate persons. And before filing this application, the corporate debtor has to undergo certain formalities. With this application, the information relating to its books of accounts and such other documents, information relating to the resolution professional to be appointed, and the most important task is the company has to pass a special resolution by the shareholders, and in case it is an LLP, at least 3/4 of the total number of the partners for initiation of the CARP. Again, this Section 10, Subsection 4, it is a repetition of that earlier portion, that if the application is complete, the NCLT may admit the application. If the application is incomplete, the NCLT may reject the application. The time available with the NCLT, as mentioned in the IBC, is 14 days. There are decided cases of the Supreme Court also that whether the time limit prescribed is 10 days or 14 days in the IBC for the adjudicating authority to decide either to accept or reject the application is mandatory or directory. The Supreme Court has clarified that the time period mentioned in the IBC is not mandatory but a directory. So a direction has been given in the IBC that the adjudicating authority in a given time frame of 14 days either admit the application or reject the application. Similarly, when the application is filed by the corporate debtor, when the CARP commencement date, it will be commenced the moment the application is accepted by the adjudicating authority. Now let us take a view of this Section 238A that was inserted by way of an amendment later on. For example, a company has availed a loan in 2005 from a bank, and after 2-3 years, the loan account of the company has become, or say classified as NPA in the books of the bank. And there was no transition in that loan account. That loan account is to be treated as debarred from the purpose, for the purpose of filing of any legal action under the Limitation Act. When this IBC was introduced in 2016, the question arises that whether the lending institution can initiate CIRP against that company for the time-barred debt. So this Section 238 was inserted in the IBC to make it a clarification that the Limitation Act 1963 applied to the proceedings or appeals before the adjudicating authority, the appellate authority, the DRTs and the debt recovery tribunals. It means the application under section 7, 9 or 10 cannot be admitted for time bar debts. So it has to be filed within the limitation period provided under the Limitation Act. In this case, BK Educational Services Private Limited, the Supreme Court opined that if the default has occurred over 3 years prior to the date of filing of the application, it would be barred under Article 137 of the Limitation Act, 1963, save and except in those cases where in the facts of the case, Section 5 of the said Limitation Act may be applied to condone the delay in such filing. So Section 238 of the Act of the Code is clarificatory of the law, and thus it is having the retrospective in effect. Retrospective means when the act came into process in 2016, when the act was enacted, since then this section 238A is retrospective in that effect. Now let us discuss on this whatever we have discussed in a limited time, just to overview what we have understood on this sections 6, 7, 8, 9 and 10. So students are requested to kindly give their options on this admin portal. The question is, who may initiate CIRP where a corporate debtor commits a default? The option given is financial creditor, operational creditor, the corporate debtor itself, or any of the above. Yes, please. Please give answer on your admin portal. One answer. Any more? The answer is last one, any of the above. Financial creditor under section 7, operational creditor under section 9, then corporate debtor under section 10. It means A, B, and C, any of the above can initiate CIRP. So the final option is D. Let us have another question. The financial creditors who are LOTs under a real estate project, means those who have booked a flat in that real estate project, an application for initiating CIRP against the corporate debtor shall be filed by individual LOTs, jointly by not less than 100 of such LOTs, jointly by not less than 10% of the total number of such LOTs, and jointly by not less than 100 or not less than 10%, whichever is less. The correct answer, yes. Some of the students has mentioned the right answer is option D. The adjudicating authority shall fill up the blanks of the receipt of application for initiation of CIRP from the financial creditor ascertain the existence of default. Now the 4 options are given within 7 days, 10 days, 14 days, and 20 days. How much time the adjudicating authority is having? Yes, please. It is the 14 days again, I am repeating that the 14 days time limit given in the IBC to the adjudicating authority is directory as decided by the Supreme Court. It is not mandatory, it is a directory. Then the corporate debtor shall fill up the blanks of the receipt of demand notice or copy of the invoice bring to the notice of the operational creditor. The option is within a period of 7 days, 10 days, 14 days, and 20 days. Option is 10 days. Let us have a last question on this. Where a corporate debtor has committed a default, a corporate applicant thereof may file an application for initiating CIRP with the adjudicating authority along with. So what we have discussed, that options are given: ordinary resolution, special resolution, board resolution, or approval of the managing director. What option is available with the corporate debtor when the corporate debtor itself intends to file CIRP? Yes, please answer MCQ 15. As we have discussed that there should be a special resolution passed by the shareholders. And the reference is given section 10, subsection 3, subclass C. Option is B, the special resolution passed by the shareholders. Yes, please. Now come to the next section 11. We have discussed section 6, 7, 8, 9, and 10. Now section 11. This section deals with the persons not entitled to make application for the CIR. Means some of the persons has been precluded, that have been debarred, or say that they cannot file the CIRP proceedings. Means a corporate debtor who is undergoing CIRP or PPIRP, financial creditor or operational creditor undergoing a PPIRP, a corporate debtor having completed CIRP 12 months preceding the date of making the application, corporate debtor in respect of whom a resolution plan has been approved under Chapter 3rd A, 12 months preceding the date of making the application, corporate debtor or financial creditor who has violated any of the terms of the resolution plan which was approved 12 months before, and corporate debtor in respect of whom a liquidation order has been made. So these 5-6 persons are not eligible to make an application for the CIRP. Then disposal of application under section 54C and under section 7, 9, or 10. Section 11A was inserted by way of an amendment. What is section 54C? 54C relates to the pre-packaged insolvency resolution process. It is solely for the MSME companies. So 3 options are given. Number 1 is the application filed under section 54C is pending, and the NCLT shall admit or reject such application before considering any application under section 7, 9, or 10. Second, application under section 54C is filed within 14 days of filing application under section 7, 9, or 10. Then NCLT shall first dispose of the application filed under section 54C. And the third option is if the application under section 54C is filed after 14 days of filing application under section 7, 9, or 10, then NCLT shall first dispose of the application filed under section 7, 9 or 10. This provision of section 11A shall not apply where an application is filed under section 7, 9 or 10 and pending as on the date of commencement of the IBC Amendment Ordinance 2021. Now the time limit for completion of the CIRP that has been prescribed, that is 180 days. From which date? The date when the insolvency commencement date. What is the insolvency commencement date? The moment the NCLT has admitted the application. From that date, the time runs. From that date, the 180 days will be counted. And if within the 180 days, the resolution plan is not approved, then the COC may recommend through the IRP or RP for extension of more time, and that time may be allowed up to 90 days. So total period of 180 plus 90 days equal to 270 days. And this extension will be granted, may be granted by the adjudicating authority for one time only. In any case, the CIRP shall mandatorily be completed within a period of 330 days from the insolvency commencement date, including any extension and the time taken in legal proceedings in relation to such resolution process of the corporate debtors. Now the question arises that can a financial creditor or operational creditor or the company itself can withdraw the application which it has filed before the NCLT? So section 12A was inserted by way of amendment that yes, it can be if it is approved by the 90% of the voting share of the committee of creditors. So it can be withdrawn. And the related regulation is regulation 30A. If the withdrawal is made before the constitution of the COC, then who will make the application? The application will be made through the IRP before the adjudicating authority. And if it is made after the constitution of the COC, then the application will be made by the applicant through the IRP or the IR or the RP. If the application for withdrawal is made after the issue of the invitation of expression of interest under section 36A, the applicant shall also state the reasons for justifying the withdrawal. So these are the procedures that section 12A along with the regulation 30A, which deals with the withdrawal of the application, and the condition is that at least 90% of the voting shares of the COC shall approve the withdrawal of the initiation of CIRP application. Then there is a prescribed form, that is form FA, and the applicant has also to submit the bank guarantee, because the moment the initiation of the CIRP has been admitted, there are certain expenses which has been incurred by the IRP or RP, and that applicant has to submit a bank guarantee that whatever the expenses has been incurred, that applicant will bear the expenses, failing which the guarantee may be invoked. The IRP shall submit the application to the NCLT on behalf of the applicant within 3 days of the receipt of where the COC is not constituted, And when the COC is constituted, the COC shall consider the application within 7 days of its receipt, and NCLT may by order approve the application so submitted for the withdrawal. Now, many of the students might be having a query that why there is a demarcation between the creditors of financial creditors and operational creditors. Yes, please. The IBC has given a or put a wall between the creditors, that is the financial creditors and operational creditors. Why it is so? Can any of the students may write on this admin portal why there was a difference between financial creditors and operational creditors? In a case, sorry, in the Swiss Ribbons Private Limited and another, Union of India and others, the Supreme Court has opined that there is a difference between the financial creditors and operational creditors. Why the difference has been made that operational creditor is concerned only with the money of the goods or services which it has provided to the corporate debt. He is concerned about his money only. But the financial creditor is also concerned with the money, but he has provided the loans and working capitals. So there is a difference between the financial creditor and the operational creditor, which in this Swiss Ribbons Private Limited and another versus Union of India, the Supreme Court has opined that in the most financial creditors, particularly the banks and financial institutions, are secured creditors, whereas the operational creditors are unsecured. Payments for goods and services as well as payments to workers not being secured by mortgage documents and the like. The nature of the loan agreements with the financial creditors differs from the contracts with the operational creditors for supplying goods and services. Financial creditors generally lend finance on a term loan or for working capital that enables the corporate debtor to set up for or operate its business. On the other hand, contracts with the operational creditors relate to the supply of goods and services in the operation of the business. Financial contracts generally involve large sum of money. In contrast, the dues of the operational creditors are generally lower. That's why the difference has been given between the creditors, financial creditors, and operational creditors. And in addition, the financial creditors have specified repayment schedules and default entitled financial creditors to recall a loan in the totality. Contracts with operational creditors do not have such stipulations. Contracts with operational creditors can and do have arbitration clauses, whereas dispute resolution is done privately. The court observed that operational debts also tend to be recurring in nature, and the possibility of genuine disputes in case of operational debt is much higher compared to the financial debt. Thus, in order to preserve the corporate debtor as a going concern, while ensuring maximum recovery for all the creditors, IBC needs to distinguish between financial creditors and the operational creditors. The difference directly relates to the IBC's objectives. So that was the decided case law in which the Supreme Court has opined that the IBC has legitimately differentiated between the creditor, that is the financial creditors, and operational creditors. Now come to the Yes, one candidate has, due to the amount involved in case of financial creditor, is greater than the operational. Very fine. Good response. Yes. Now come to the section 13. The NCLT after admission of the application under section 7 means financial creditor, section 9 operational creditor, and section 10 by corporate debtor. By order declare the moment the application is accepted, the adjudicating authority will declare a moratorium. Then cause a public announcement for initiation of the CIRP and call for submission of claims. Appoint an IRP, and public announcement shall be made immediately after the appointment of the IRP. So section 13 provides 3-4 points: declaration of moratorium, public announcement, appointment of IRP, and the public announcement should be made immediately after the appointment of the IRP. Now come to the section 14. Section 13 provides that declaration of moratorium, what it means. Moratorium means prohibiting all types of followings. Means no institution of suits, no transferring, encumbering, alienation, no action of foreclosure, recovery of any property. It means if any of the parties either have filed a suit against the corporate debtor for recovery of the dues, that suits will be temporarily stayed. That is called the moratorium. If the decree has been passed by any court, the execution of the decree will also be stayed. Why the moratorium has been provided? It is a cooling period, just to think over that how this corporate debtor may survive, just to think over the process, that what are the resources a corporate debtor may raise by way of interim finance, how the company may survive, how the company may run again on its feet as a going concern, like that. This is the whole purpose of the moratorium which the section 14 provides. A very good point, that is subsection 2 or subsection 2A of section 14 provide that supply of essential goods and services should not be suspended during the moratorium. Because if the essential services or goods are prohibited or not supplied to the corporate debtor, how a corporate debtor will survive or will go on. So this subsection 2 and subsection 2A have provision that the supply of essential goods or services to the corporate debtor shall not be terminated or suspended or interrupted during the moratorium period. Now, the moratorium shall not be applicable such transactions, agreements, or other arrangements as may be notified by the central government in consultation with any financial sector regulation or any other authority. A surety in a contract of guarantee to a corporate debtor. To understand this, section 14, subsection 3, subclass B, let us have an example that a company has availed loan from a bank. Its promoter or say a director has given a guarantee to the bank that in case the company do not pay, I will pay the amount. Okay, that is the guarantor, that is the surety. the question is that if a moratorium is imposed on the company when the application for the CIRP, initiation of CIRP by the financial creditor has been admitted by the NCLT, whether the moratorium on the guarantor is also applicable. So this section 14 by 3, subsection 3, it clearly mentioned that the provisions of section 14, subsection 1 shall not apply to a surety in a contract of guarantee to a corporate. Now, the moratorium, once imposed, when it will cease. Section 14, subsection 4 provides that order of moratorium shall have effect from the date of such order till the completion of the CIRP. It means when the completion of the CIRP is completed, then the order for the moratorium will also comes to an end. If the resolution plan is accepted, moratorium will come to an end. If the resolution plan is not accepted, the adjudicating authority may order for the closure or the winding up of the company. Then again, the moratorium will come to an end. There is a case law on this, section 14. In Alchemist ARC, the Supreme Court opined that once a moratorium is imposed under the IBC, any proceedings initiated against the corporate debtor does not exist in law. Means all the proceedings, whether lying or proposed by any person against the corporate debtor, shall be kept in abeyance till the decision of the survival or the winding up is decided by the adjudicating authority. In another case, titled as Canara Bank versus Deccan Chronicle Holdings Limited, the appellate authority opined that moratorium will not affect any proceedings initiated or pending before the Supreme Court under Article 32 or under Article 136 or under Article 226 of the Constitution. Now let us have an overview what this Article 32, 136 or 226 describes about that. Article 32 describes about the fundamental rights. Article 136 vests with the Supreme Court of India with a special power to grant a special leave to appeal against any judgment. And Article 226 empowered the High Court. So again, come back to the preceding slides. Then section 14 in this Canara Bank versus Deccan Chronicle Holdings, the appellate authority opined that moratorium will not be affected by any proceedings initiated under Article 32, 136 and 226 of the Constitution. In a famous case, Anju Agrawal, that lady was RP in Sri Bhavani Paper Mills Limited. It was opined by the appellate authority that Section 28A of the SEBI Act is inconsistent with Section 14 of the IBC and that the latter will prevail over the former, and the SEBI cannot recover any amount, including the penalty from the city. The Bombay Stock Exchange cannot take any coercive steps against the CD, nor can it retain the CD for suspension of the trading of the shares. What happened in this case is that for any malpractices or any non-compliance, SEBI has penalize the company, but due to the moratorium imposed and the IBC prevails over any other laws, the appellate authority opined that SEBI cannot recover any amount, including the penalty from the corporate debtor. In another case, the ICICI Bank Limited versus the IRP for the Ruchi Soya, it was opined by the appellate authority that once the moratorium is declared, it was not open to the bank to debit any amount from the amount of the CD, corporate debtor. What happened in this case, that the bank, that is the ICICI Bank, has debited the account of the Ruchi Soya and recovered some of the charges. But since the moratorium was imposed, the appellate authority that opined that when the moratorium is declared, the bank cannot make any debit entry in the account of the corporate debtor. Now there is a famous case on the supply of essential goods and services under the moratorium in Shyam Pradhan and another versus Anand Chandra Swain. In this, the court opined that insurance cover of the corporate debtor held that the policy could not be terminated since it is an essential for the very existence of the corporate debtor. What it means that the corporate debtor is to continue as a going concern, so insurance policy is must. The appellate authority also directed the IRP to pay the insurer any amount owing as an installment during the CIRP. Moratorium do not apply on the personal guarantor of the CD, as we have discussed just now, that moratorium is applicable on the corporate debtor itself and not on the personal guarantor of the corporate debtor. In this case, the State Bank of India versus Ramakrishna, the Supreme Court held that Section 14 did not apply to the personal guarantor of the CD, but only to the corporate debtor itself. Now, what we have seen that when the commencement of the CIRP begins, the IRP has to make a public announcement. So what are the contents of the public announcement that has been described in Section 15? It contains the name and address of the corporate debtor, name of the authority with which the corporate debtor is incorporated or registered, last date for submission of claims, details of the IRP, penalties or false or misleading claims, and the last date, and when the CIRP will cease to have effect, that is the date when the 180th date from the date of admission of the application. That has to be mentioned in such that public announcement. When the public announcement shall be made? In the IBC, it is mentioned that insolvency professional shall make public announcement immediately. What is the meaning of immediately? The word immediately has been defined under Regulation 6. It means not later than 3 days from the date of his appointment. And that public announcement has to be made in Form A, which has been prescribed in this Regulation 6. And there are certain procedures of displaying the Form A in the newspapers, one in English and one in vernacular languages. Then the website of the corporate debtor and IBBI's website, and choice of 3 insolvency professional to act as an authorized representative, and the last date for submission of the claims. One question has been raised that whether two applications of insolvency will be filed, one against the CD and other against the surety together. In Contract Act, the liability of the guarantor coexistence with the corporate debtor. So we may have two options. You may file the initiation of the CIRP or the civil suit against the corporate debtor or against the individual surety, or simultaneously with both persons, or you may prefer not to file the CIRP against the corporate debtor, but to file the CIRP against the surety alone. Once moment the default has occurred by the corporate debtor, you may initiate the CIRP against the guarantor also, because you have the option to recover the amount either from the corporate debtor or from the guarantor, or from the guarantor alone, or from the corporate debtor alone, or simultaneously with both. So the answer raised by the student is that one may initiate the CIRP against both these persons. Now the next question is that where the CIRP against that corporate guarantor will be initiated. Let us take an example. A company is having a registered office in Delhi. Okay. And the person who has given the guarantee is having the residential address in Ahmedabad. Okay. Then where the CIRP proceeding against the guarantor will be initiated? In the NCLT Ahmedabad or in NCLT Delhi? The answer is that, which has been provided under the IBC also. The answer is where the registered office of the corporate debtor is situated. Where the registered office is? Registered office of the corporate debtor is Delhi. So the initiation of the CIRP against the surety will also be made in the Delhi NCLT. Yes, please. Jai Srivastava, am I correct? Answer. So you have the option either to initiate the CIRP against the corporate debtor or against the surety simultaneously with both of the persons. Now, claims by the operational creditor. Regulation 7. A person claiming to be an operational creditor other than workman or employee of the corporate debtor shall submit claim with proof of the IRP in person by a post or electronic means and form number B of the schedule. So the succeeding slides provides the requisite forms. Form B for the employees, then claims by the operational creditors, how it will be provided. Okay, thank you. Jai Srivastava. The existence of the debt due to the operational creditor under this regulation may be proved on the basis of the records available with the information utility or any other documents or contract for supply of goods or services, invoice demanding payment, order of a court or tribunal, financial accounts. These may be the supplementary proof or the documentary proofs which the operational creditor may submit. Then financial creditor may submit Form C that has been prescribed. These are the relevant documents which has to be attached with the Form C. Then claim by creditors in a class. These are to be submitted in Form CA. These are from the regulations which I have taken. That may or may not be much relevant, because in the study materials we have to focus on the IBC itself and the relevant regulations also. So I am skipping these 2-3 slides rapidly. Now the verification of the claims by regulation 13. When the claims have been submitted by different persons, that is the financial creditors, employees, operational creditors, all these claims have to be scrutinized by the IRP or RP within 7 days from the date of receipt of the claims. And thereafter, the IRP has to make a list of that creditors. And from that list of creditors, it has to constitute a committee of creditors. After verification of the claims are to be displayed on the website of the corporate debtor, on the website of the IBBI, and he has to determine that certain parties are having so much of the outstanding loans. Regulation 14 provides that where the amount claimed by a creditor is not precise, not clear, due to any of the contingency or any reason, the IRP or RP shall make the best estimate of the amount of the claim based on the information available with him. IRP shall revise the amount of claims admitted, including the estimates of the claims made under Sub-Regulation 1, as may be practicable when he comes across additional information warranting such revision. Appointment and tenure of IRP, Section 60. As we have discussed that when the application for initiation of CIRP is admitted by the NCLT, the NCLT appoints the IRP. Now the CIRP initiated by the financial creditor or the corporate debtor, the resolution professional proposed by the financial creditor or the corporate debtor shall be appointed by the IRP, provided no disciplinary proceedings are pending against him. And when the CIRP is initiated by the operational creditor and the operational creditor has not proposed in his application the name of any IRP, then what reports is available with the NCLT? The NCLT will make a reference to the board, that is the IBBI, to suggest a name of insolvency professional to act as an IRP, and the IBBI shall, within 10 days of the receipt of reference from the NCLT, will recommend the name of the IRP, and the term of the IRP shall continue till the date of appointment of the RP. What is the eligibility of the resolution professional that is contained in Regulation 3? It provides that an IP shall be eligible to be appointed as an IRP or RP, as the case may be, for CIRP of a corporate debtor if he and all partners and directors of the insolvency professional entity IPE of which he is a partner or director are independent of the corporate debtor. Means they should not be associated with, they should not be the employee, they should not have been the auditor, for the past 5 years or more. So in any way, they should not have any relationship with the corporate debtor. That should be having the independent status. A person shall be considered independent of the corporate debtor. And what is the criteria of the independence that has been prescribed under Section 149 of the Companies Act 2013, that is not a related party, not an employee, not an auditor or secretary auditor, not holding share of 5% or more in the gross turnover of the such firm, like that. Where the committee of creditors decides to appoint the IRP as the RP or replace the IRP under Section 22 or replace the RP under Section 27, it shall obtain a written consent of the proposed RP in form AA of the schedule. There might be certain circumstances that when the committee of creditors is constituted, the COC may want to retain the same person, same IRP as the RP, or may want to change the another person to have that person as the RP. What will happen? They will pass the resolution in the committee of creditors and will propose the name of the proposed new RP to the adjudicating authority, and the adjudicating authority will examine the situation that the committee of creditors have, along with that application, has also sent the consent letter, and that new RP is not having any disciplinary proceedings pending with the IBBI, then it can confirm the name of the proposed RP. And till that new RP is appointed, the present IRP will continue to function as the RP. This is the eligibility criteria of the resolution professional under Regulation 3. Now come to the Section 17, the management of affairs of the CD by IRP under Section 17. This section provides that IRP is to look after the management of the affairs. The moment the IRP is appointed, the powers of the board of directors are suspended. We are using the words used in the IBC is suspended. Please pay attention. The words used are suspended, not the terminated. Board of directors, the powers of the board of directors are suspended. All of the board of directors are not terminated. Only the powers of the board of directors shall stand suspended and will be exercised by the IR. The officers and managers of the corporate debtor shall report to the IRP. And if any of the officers and managers of the corporate debtor is not responding or not making compliance of the instructions given by the IRP, then what recourse is available to the IRP is that he can make a representation to the adjudicating authority for the direction. And the adjudicating authority may give direction to the corporate debtor to abide by the orders of the IRP or RP, as the case may be. Now the powers of the IRP has been mentioned in Section 17, Subsection 2, that IRP vested with the management of the corporate debtor shall act and execute it in the name and on behalf of the corporate debtor, take such action, have the authority to access the electronic records, have the authority to access the books of accounts, and be responsible for complying with the requirements under any law. Under any law means any of the law which the company has to make the compliance for the time being in force on behalf of the corporate debtor. Regulation 4 provides that IRP shall have the right to have the access of the books of accounts with the depository of the securities, professional advisors, information utilities like that. Along with the powers of the IRP, Section 18 lists out the duties of the IRP. What are these duties? To collect all the informations relating to the assets, financial operations, and financial position of the corporate debtor for the last 2 years. List of the assets and liabilities as on the initiation date. Receive and collect all the claims. Constitute a committee of creditors. Monitor the assets of the corporate debtor and file information collected with the information utility if any necessary. Take control and custody of any of the assets. So you see the importance of the IRP, the powers and duties which are vested with the IRP. Since the IRP is appointed by the adjudicating authority, it means he is treated as an officer of the court, officer of the tribunal. He has to take over all the assets, whether the assets are lying within India or abroad. Take control and custody of any of the assets. Assets or with the corporate debtor has ownership rights which may be located in the foreign countries as well. Assets that may or may not be in possession of the corporate debtor. Somebody else is having the possession of the assets of the corporate debtor. All the assets, whether it may be the tangible assets, intangible assets, securities, all type of assets. But following are not to be included in the assets. So Section 18 also prescribes that these shall not form the part of the assets. Which are they? That the assets owned by a third party in possession of the corporate debtor, held under trust or under contractual agreements including bailment. Assets of any Indian or foreign subsidiary of corporate debtor, and such other assets as may be notified by the central government in consultation with any other financial sector regulator. Now let us discuss on the case law in Core Asset Reconstruction Company, in which the appellate authority opined that it is the duty of the IRP to take control and custody of any asset over which the CD has ownership right. Therefore, if such asset is not in the possession of the CD, the person in possession of the same is bound to hand over the same to the RP. There may be circumstances that some other person might be having the possession of the assets of the corporate debtor. So it is the duty of the corporate, it is the duty of the IRP to take possession of that assets into his custody. As we have discussed that if any of the persons of the corporate debtor is not abiding with the orders of the IRP, then IRP may make a reference to the adjudicant authority for the directions. And the concerning officials are supposed to extend full cooperation to the IRP in his day-to-day working. Because the IRP is the person who has to run the company as a going concern. So Section 20 deals with the management of operations of the corporate debtor as a going concern. So how the IRP will discharge its functions? He may appoint accountants, legal professionals, or any other professional to enter into contact on behalf of the corporate debtors he has the right to raise the interim finance, provided that no security interest shall be created over any encumbered property of the corporate debtor, and provided that no prior consent of the creditor shall be required where the value of such property is not less than the amount equivalent to the twice of the amount of the debt, and to take all such actions which are necessary to keep the corporate debtor as a going concern. Now, let us revise whatever we have discussed by way of some MCQs. Students, kindly revert their answer on the Admit Board portal, please. The adjudicating authority may allow the withdrawal of application admitted under section 7, 9, or 10 on an application made. Now the four options are by the IRP, by the applicant with the approval of 66% of the voting share of the COC, by the applicant with the approval of 75% of the voting share of the COC, and by the applicant with the approval of 90% of the voting share of the COC. Yes, please. By the applicant with the approval of 90% of voting share of the. Students might be confusing that option B and C 66% or 75%. Actually, the demand of the question is when the application for initiation of CIRP can be withdrawn. That is the 90% of the voting share of the COC, and that has been prescribed under section 12A, which was inserted by way of an amendment. The adjudicating authority shall appoint an IRP, fill up the blanks, from the insolvency commencement date. Now the four options are given: within 7 days, after 7 days, within 14 days, and on the insolvency commencement date. And adjudicating authority shall appoint an IRP, fill up the blanks, from the insolvency commencement date. Yes, please. So the answer is on the insolvency commencement date. The IRP shall be appointed by. It means who is the appointing authority of the IRP. Fill up the blanks within 14 days from the insolvency commencement date. The options are adjudicating authority, COC, financial creditor, or operational creditors. Who is the appointing authority of IRP? The appointing authority of the IRP is the adjudicating authority, as we have discussed that the IRP or RP is appointed by the adjudicating authority. It means he is the officer of that tribunal. What is the term of the IRP? It shall continue till the appointment of resolution professional. It shall not exceed 60 days from the date of his appointment. It shall not exceed 90 days from the date of his appointment. IRP may continue till the decision of the adjudicating authority. Yes, please. What is the term of IRP? The IRP may continue till the new RP is appointed. It means the option A, and the reference is section 16, subsection 5. From the date of appointment of the IRP, the officers and managers of the corporate debtor shall report to किसको report करना चाहिए? To whom the IRP, to whom the officers and managers of the corporate debtor shall report? To the managing director, COC, IRP, or the adjudicating authority? The option is IRP. Now, friends, let us have a break for 10 minutes. And right now it is 8:45. We will resume again sharp by 8:55. Okay, Nisarg ji. Welcome again, friends. Now, section 21. This section provides that IRP shall, after collation of all the claims received against the corporate debtor and determination of the financial position of the corporate debtor, constitute a committee of creditors. The committee of creditors shall comprise all financial creditors of the corporate debtor. The creditors may be financial creditors and operational creditors, but as per the provisions of section 21, the COC shall comprise of financial creditors only. Where there are no financial creditors and there are only financial operational creditors, that scenario we will be discussing in the next succeeding slides. The proviso 1 that provides that a financial creditor or the authorized representative of the financial creditors, if it is a related party of the corporate debtor, shall not have any right of representation, participating or voting in a meeting of the COC. It means the financial creditors should not be related party if that financial creditor or the related party are participating in the COC. They shall not have any right of representation or they cannot vote in the meeting of the COC. Proviso 2 provides that first proviso shall not apply to a financial creditor regulated by a financial sector regulator if it is a related party of the corporate debtor solely on account of conversion or substitution of debt into equity shares or instruments convertible into equity shares or completion of such transaction as may be prescribed prior to the insolvency commencement date. So proviso 2 has again clarified that these persons shall not be termed as a related party to the corporate debtor. Section 21, subsection 3 provides that subject to means condition, subject to subsection 6 and 6A, where the corporate debtor owes financial debt to two or more financial creditors as part of consortium or agreement. Each such financial creditor shall be part of the committee of creditors and their voting shares shall be determined on the basis of the financial debts owed to them. What is consortium financing? That more than one or two banks, there may be 5 or 6 banks who have agreed to give finance to a company, and they all have jointly participated in the in providing the credit facility to the company. That is called the consortium arrangement. Subsection 4 provides that where any person is a financial creditor as well as operational creditor, means he is enjoying both type of position, then what will happen? Then such person shall be financial creditor to the extent of the financial debt owed by the corporate creditor and shall be included in the committee of creditors with voting share proportionate to the extent of the financial debts owed to them, to such creditor. And such person shall be considered to be an operational creditor to the extent of the operational debt owed by the corporate debtor to such creditor. It means to that extent his debt is termed as a financial debt. Only for that debt he is having the voting right. Subsection 5 further describes that where an operational creditor has assigned or legally transferred any operational debt to a financial creditor, the assignee or transferee shall be considered as an operational creditor to the extent of such assignment or legal transfer. It means that assignment of debt by the operational debtor to the financial creditor will not convert the debt from operational to the financial debt. Subsection 6 provides that where the terms of the financial debt extended as part of consortium arrangement or syndicated facility provided for a single trustee or agent to act for all financial creditors, each financial creditor may authorize a trustee, represent himself in the COC, appoint an insolvency professional, and exercise his right to vote to the extent of the voting share with one or more financial creditors jointly and severally. Where the financial debt is in the form of securities or deposits, and the terms of the financial debt provide for appointment of a trustee or agent to act as authorized representative for all financial creditors, such trustee or agent shall not act on behalf of such financial creditors. Further, subsection 6A provides that where a financial debt is owed to a class of creditors exceeding the numbers as may be specified, the IRP shall make an application to the adjudicating authority along with the list of all financial creditors containing the name of the insolvency professional other than the IRP to act as their authorized representative, who shall be appointed by the adjudicating authority prior to the first meeting of the COC. Where a financial debt is represented by a guardian, executor, or administrator, each person shall act as authorized representative on behalf of such financial creditor, and such authorized representative shall attend the meeting of the COC and vote on behalf of such financial creditor to the extent of his voting share. The remuneration payable to the authorized representative shall be as per the terms of the financial debt or the relevant documentation, and shall be specified, which shall be formed part of the insolvency resolution process cost. The board, that is the IBBI, may specify the manner of voting and determination of voting shares in respect of financial debts covered under subsection 6 and 6A. Subsection 8 provides that save as otherwise provided in this code, all decisions of the committee of creditors shall be taken by a vote of not less than 51% of the voting share of the financial creditor. Students may please note that subsection 8 mentions not less than 51% of the voting share. One should not be confused with the 66% which have been mentioned somewhere else in the IBC. Here in subsection 8, all the decisions of the COC shall be taken by a vote of not less than 51% of the voting share. The proviso to this subsection provides that where a corporate debtor does not have financial creditor, and the COC shall be constituted and shall comprise of such persons to exercise such functions in such manner as prescribed in Regulation 16. What is contained in section 16, we shall be discussing in the succeeding slides. Subsection 9, the COC shall have the right to require the RP to furnish any financial information in relation to the corporate debtor at any time during the CIR. And RP shall make available all financial information so required by the COC within a period of 7 days of such requisition. So section 21 deals with the constitution of the committee. Let us revise this section. That is the constitution of the committee. Constitution of the committee shall comprise of only the financial creditor. Then proviso 1 and 2 has been provided that is the right of representation, and where two or more financial creditors are there, then there is a provision of consortium. When a person is having both the status, financial as well as the operational creditor, only the financial debt will be considered. And when the operational creditor has assigned, it will not change the status of the operational debt to the financial debt. And they may provide a single trustee or agent to act on behalf of all the financial creditors, where the consortium arrangement or the credit facility provides so. So this was all about the section 21 relating to the constitution of the Committee of Creditors. Now come to the part that when section 21 says that Committee of Creditors should only be of the financial creditors. What will happen when there are no financial creditors? It means company is not having any outstanding loans from any banks or financial institutions, and only the operational creditor has initiated the CIRP. Then in that case, how the COC will be formed, that has been described in regulation 16, which states that where the corporate debtor has no financial debt or where all the financial creditors are related party of the corporate debtor, the committee shall be set up in accordance with these regulations. That is 18 largest operational creditors by value. And if the corporate debtor is having less than the 18 number, then it may be such numbers. It may be 10, 11, 15 or 5, 6, whatever it may be. But if it is less than 18, then the number of operational creditors less than 18 may be considered. Then one representative elected by all the workmen and one representative elected by all the employees. So 18 plus 1 plus 1 means the 20 persons will form the constitution of the committee, and the member of the committee formed under this regulation shall have the voting rights in proportion of the debt due to such creditor or debt represented by the such representative as the case may be. Percentage of the total debt. Explanation provides the meaning of the total debts. Total debts means the amount of debt due to the creditors, amount of the aggregate debt to the workmen, amount of aggregate debt to the employees. Committee formed under this regulation and its members shall have the same right, powers, duties, and obligations as the committee comprising financial creditors and members as the case may be. It means this committee will have the same powers as the powers which are being vested with the committee having the financial creditors. Now the appointment of the resolution professional. First meeting of the COC. In the first meeting of the COC, which is supposed to be held within 7 days of the constitution of the Committee of Creditors. And the Committee of Creditors may, in the first meeting, by a majority of not less than 66% of the voting shares of the financial creditors, either resolve to appoint the IRP as a RP or to replace the IRP by another RP. Here the words used are 66% of the voting share. Means if the members of the COC wants to change the existing IRP with the another person as RP, then 66% means not less than 66% of the voting shares are required. Either to resolve the IRP as the RP means they can confirm that the same IRP will act as an RP, or may replace the this present IRP by the another RP. Now, subsection 3 provides that where the committee decides to continue the IRP as RP, obtain the written consent from the existing RP and file the application before the NCLT, and the NCLT will confirm. The second option that is mentioned in subclass B2 subsection 3 of section 22, that if the COC wants to replace the existing RP, then obtain the consent of the proposed RP, file application with the NCLT, and obtain the written confirmation from the adjudicating authority. Then NCLT shall forward the name of the proposed RP to the board, that is the IBBI, for confirmation. What type of confirmation? Just to ensure that no disciplinary action is pending before the or against the proposed RP. Then the board will confirm that yes, no disciplinary action is pending with the proposed RP. Then the NCLT will confirm the name of the new RP. RP to conduct CIRP. Many a times the question may be asked that who conducts the RP? IRP or RP? It is the RP only, because if the IRP has been allowed to continue, then he will be deemed as an RP, not the IRP. And when the new person has been appointed, he is the new RP. So it is the RP, it is the resolution professional who is to conduct the CIRP. Many times it also leads to the confusion that whether there is a difference between the insolvency professional and resolution professional. Yes, it is there. Who is the insolvency professional? Insolvency professional is a person who has passed certain examination conducted by the IBBI, passed certain hours of training, and is a registered member of IPA and IBBI. Okay. But he has not been appointed by the adjudicating authority to conduct the CIRP proceedings. The moment the insolvency professional is appointed by the adjudicating authority, he is deemed as IRP or RP. And then IRP continues as RP, then RP is to conduct the CIRP. Is it clear, friends? So section 23 deals with that the RP is to conduct CIRP. Now let us discuss on this, that RP shall conduct the entire CIRP and manage the operations of the corporate debtor during the CIRP period. RP shall continue to manage the operations of the corporate debtor after the expiry of the CIRP period until an order of approving resolution plan appointing a liquidator under section 34 is passed by the adjudicating authority. RP shall exercise powers and perform such duties as are vested or conferred on the IRP. In case of appointment of a RP, the IRP shall provide all the information, documents, and records pertaining to the corporate debtor in his possession and knowledge to the resolution professional. Now, section 24. The members of the COC may meet in person or by such other electronic means as may be specified. It may be through the video conferencing or any other electronic means, or they may meet offline, means in person. And all the meetings of the COC shall be conducted by the RP. The RP shall give notice of each meeting to the COC to the members of the committee, number one. Along with that, members of the COC, the members of the suspended board of directors are also to be invited. Again, operational creditors or their representatives, if the amount of their aggregate dues is not less than 10% of the debt. So there are three types of persons, three categories of the persons who are invited in the meeting of the COC. That is the members of the COC, suspended members of the board of directors, and the operational creditors whose outstanding is not less than 10% of the debt. Subsection 4 of section 24 further elaborates that the directors, partners, and one representative of operational creditors may attend the meetings of the COC. Please pay attention that may attend the meeting of the COC, but shall not have any right to vote in such meeting. They can attend, they are the observers only, they cannot participate in the voting. Further, the absence of such director, partner, or representative of the operational creditors shall not invalidate the proceedings of such COC meeting. Subsection 6, 6A, and 6B of section 21. Any creditor who is a member of the COC may appoint an insolvency professional other than the resolution professional to represent such creditor in a meeting of the COC. Means these persons may appoint any insolvency professional. Now the words used are insolvency professional. Means they may appoint any insolvency professional who is registered with the IBBI and IPA to act as the representative in the COC meeting. And the fees of the insolvency professional shall be borne by their appointing person, that is the individual creditor. Subsection 6 of section 24 provides that each creditor shall vote in accordance with the voting share assigned to them. Let us take an example that a corporate debtor have availed loan, say 100 crores rupees, and 5 banks have participated in the credit facility provided to the corporate debtor. Okay. So 30% share is of bank A. Rest of the banks are enjoying 20%, and like that. So the total debt is 100 crores. So bank A's voting power shall be 30 divided by 100. It means he is having a 30% of weightage in the voting share. And accordingly, rest of the financial creditors, rest of the lending institutions will be having the voting share in accordance with the debt outstanding, shares assigned to them based on the financial debts owed to such creditors. And RP shall determine the voting share to be assigned to each creditor in the manner specified by the IBBI. The meetings of the COC shall be conducted in such manner as may be specified, that has been mentioned in the regulations. Let us consider one case. In Vijay Kumar Jain, the Supreme Court opined that resolution plans need to be provided to members of the suspended board of directors of the corporate debtor, as they have right to participate in the meeting of the COC. As we have seen that when the RP is convening a meeting of the COC, The financial creditors are supposed to attend and they have the right to vote. Similarly, the notice of the meeting are also being sent to the members of the suspended board of directors. So the Supreme Court has opined that whatever the resolution plans is solicited by the resolution professional, that resolution plans need to be provided to the members of the suspended board of directors because they are also having concern with that, but they cannot participate in the voting, but they have right to participate in the meeting, so they may be provided the copy of that resolution plan. Regulation 18 provides that a RP may convene a meeting of the committee as and when he considers necessary. Sometimes a question is asked, maybe that what is the periodicity of convening a meeting, when such meeting shall be called by the RP. So regulation 18 specifies that RP may convene a meeting of the committee as and when he considers necessary, and shall convene a meeting if a request to that effect is made by the members of the committee representing 33% of the voting rights. I am a lender to the corporate debtor and the RP is not convening a meeting, and if I intend, as a lender, if I intend to call a meeting, I may make a representation. If I am having a voting right of more than 33%, then I may make a representation to the RP to please convene a meeting. Then RP, considering my request, because I am representing more than 33% of the voting rights, then RP may convene a meeting. Regulation 19 describes that how the meeting should be conveyed, how the notice of the meeting should be given. It describes that the meeting of the committee shall be called by giving not less than 5 days. 5 days notice in writing to every participant who is entitled to attend the meeting. And how the notice may be given, it may be by the hand delivery, physical delivery, by post, in accordance with the regulation. It may be through the email also. Whether this 5 days can be reduced, yes, it can be. The committee may reduce the notice period of 5 days to such other period of not less than 24 hours as it deems fit. So the committee have the powers to reduce the minimum period of 5 days notice. Then the question may be that what is the quorum of the COC meeting? The meeting of the committee shall be quorate if the members of the committee representing at least 33% of the voting rights are present, either in person or through the video. Again, repeat the example that corporate debtor has availed the loan and the loan outstanding is 100 crores. And the lenders are 5. 5 banks have given the credit facility. Out of these, 2 banks are only participating and rest 3 banks are not participating. And these 2 banks are representing at least 33% of the voting rights. It will be presumed that quorum is present in the meeting. That is sufficient. If the other lenders are not attending the meeting, okay. By not attending the meeting of the COC by the other 3 members will not invalidate the meeting, because the persons who are attending the meeting is fulfilling the criteria of at least having 33% of the voting rights. Now, the committee may modify the percentage of the voting rights. This 33% can be modified with the unanimous decision of the committee members. Then regulation 22 subclass 2 further provides that where a meeting of the committee could not be held for want of quorum, then unless the committee has previously decided otherwise, meeting shall be automatically adjourned at the same time and place on the next day. Same time and place on the next day. If today's meeting has not been convened due to the quorum, it will be held on the next day and at the same time. Then what is the duties of the resolution professional? That has been described in section 25. It shall be the duty of the RP to preserve and protect the assets of the corporate debtor. For the purpose of subsection 1, RP shall undertake the following actions, namely, take immediate custody and control of all the assets of the corporate debtor, represent and act on behalf of the corporate debtor with third party, raise interim finance subject to the approval of the committee of the creditor. There is a difference between the duties which have been entrusted in the IBC on the part of the IRP and RP. The duties of the IRP to take possession of all the assets, constitute the COC, while section 25 deals with the duties of the RP, and RP's duties is not even to take the custody and control and running of the corporate debtor as a going concern, but it is also his duty to raise the interim finance subject to the approval of the committee and prepare the information memorandum, display it on the website of the corporate debtor and on the website of the IBBI, and to call the expression of interest from the resolution applicants to submit the resolution plan. He has also have the duty to appoint accountants, legal professionals, as may be specified by the board, maintain an updated list of the claims, convene and attend all the meetings of the COC, prepare the information memorandum in accordance with section 29, and invite the prospective resolution applicants. Present all the resolution plans at the meeting of the COC, file application for avoidance of transactions, and such other action as may be specified by the board. Now, rights and duties of the authorized representative of the financial creditors. So far, we have discussed that the rights and duties of the IRPs and RPs. Now, this section 25A was inserted by way of amendment in the IBC code, that the person who is representing the financial creditors, whether he has any rights or whether any duties has been cast on that authorized person, yes. The right to participate means the authorized representative have the right to participate and vote in the meeting of the COC on behalf of the financial creditors to which he is representing, and he may vote with the prior voting instructions of such creditors obtained through physical or electronic means. It means that if the authorized representative have received the mandate from the financial creditors, then only he can vote in the meeting. Further, subsection 2 describes that it shall be the duty of the authorized representative to circulate the agenda and minutes of the meeting of the COC to the financial creditor he represents. So he is witnessing, he is observing whatever the proceedings is being discussed in the COC meeting. Since he is representing the financial creditors, so he has to circulate the agenda or minutes to the financial creditors of which he is representing. It is the duty of the authorized representative. And such authorized representative shall not act against the interest of the financial creditor. Suppose the financial creditor has authorized to vote in favor of in the particular proposal in the COC meeting, and the authorized representative is casting his vote not in favor of that proposal, it will be against the mandate given by the financial creditor. So whatever the instructions the financial creditors have passed, the authorized representative shall act according to that mandate or that instructions only. The second proviso of subsection 3 provides that if any financial creditor does not give prior instructions to the authorized representative, he shall abstain from the voting. So the instructions are very much clear, which have been mentioned in the IBC itself, that whatever the mandate is given by the financial creditor to its authorized representative, he shall act according to that mandate or that instruction only. And if he has not received any mandate, he shall remain absent from voting in that meeting. Then subsection 3A was inserted by an amendment in the IBC. And the wordings starts with the words, notwithstanding anything contrary contained in subsection 3. The authorized representative shall cast his vote on behalf of the financial creditors, of which he represents in accordance with the decision taken by a vote of more than 51% of the voting share of the financial creditors he represents, who have cast their vote, provided that for a vote to be cast in respect of an application under section 12A, the authorized representative shall cast his vote in accordance with the provisions of subsection 3. Yes, one candidate has asked a question, what is the information memorandum? Information memorandum is prepared by the resolution professional, which describes about the information relating to the company and what are its company's prospects, liabilities, financial information altogether, so that by reading the information memorandum, any of the resolution applicant who wish to make a proposal in the COC meeting that, yes, I wish to make a resolution plan. So by reading that information memorandum, he can have an idea about the company, how the loan outstandings are, what were the defaults, what are the number of creditors, what are the net worths of the company, what is the capital of the company, the extents, the promoters, everything. You may simply mean that information memorandum is just like a prospectus inviting the resolution applicants to put a resolution plan. Because suppose I wish to make a resolution plan in the COC, then how I will come across the information relating to the company. So information memorandum is a brochure. It's just like a prospectus, that from that memorandum I may have the knowledge about the company's financial intricacy and information, so that I may plan accordingly that how much amount I have to invest in order to have the acquisition of that company or to run that company. Is it clear, Jay Srivastav? Then subsection 4, the authorized representative shall file with the COC any instructions received by way of physical or electronic means from the financial creditor he represents for voting in accordance therewith, to ensure that appropriate voting instructions of the financial creditor he represents is correctly recorded by the IRP or RP, as the case may be. So whatever the mandate the authorized representative is having from their financial creditors, that mandate has to be given to the concerning RP, so that he may vote on the proposals discussed in the COC meeting accordingly. Section 26. It deals with the application for avoidance of transactions not to affect proceedings. The filing of an avoidance application by the RP shall not affect the proceedings of the CIRP. Section 27, replacement of RP by the COC. We have discussed that initially the adjudicating authority appoints the IRP. When the IRP collects the claims and constitute the committee of creditors, then the COC, that is the committee of creditors, decides in the first meeting whether to continue with the same IRP as RP or to appoint another RP. Now the question is, section 21 provides that where the COC is not satisfied with the manner of working of the present RP, whether they can replace the RP with another RP. Yes. So section 27 prescribes the procedure. It says that where at any time during the CIRP, the COC or the creditors is of the opinion that the RP appointed under section 22 is required to be replaced, they may replace him with another RP. And what is the procedure? That procedure has been described, that the COC may at a meeting by a vote of not less than 66% of the voting share resolve to replace the RP appointed under section 22 with another RP. Procedure is same, that they have to obtain the written consent and in the specified form and then forward the application to the NCLT. The NCLT will forward the application to the IBBI just to ensure that there are no disciplinary proceedings pending with against the proposed RP. And if the IBBI confirm, then the adjudicating authority will confirm the appointment of the new RP. So section 27 have the provision that if the COC want to replace the existing RP, they may do so. Then section 28 deals with the approval of the COC for certain actions. Notwithstanding anything contained in any other law for the time being in force, the RP during the CIRP shall not take any of the following actions without the prior approval of the COC. So what we have discussed, that when the RP is taking charge or having the control of all of the affairs of the corporate debtor, but the RP is taking the instructions from the COC, and without the approval of the COC, the RP cannot do the following under mentioned transaction. RP can raise the interim finance, but for that, the approval of the COC is required. The subclass A mentions that RP may raise any interim finance in excess of the amount. It means for this, he has to take the approval of the COC. Further, RP shall not create any security interest over the assets of the creditor, of the corporate debtor, and change the capital structure of the corporate debtor, including by way of issuance of additional securities or creating a new class of securities or buying back or redemption of the issued securities in case the corporate debtor is a company. So for these reasons, the RP has to take the prior approval of the COC. Furthermore, record any change in the ownership interest of the corporate debtor giving instruction to the financial institutions, undertaking any related party transactions, amending the constitutional documents, that is the MOA or AOA of the corporate debtor, delegation of its authority to any other person. All these things require the prior approval of the COC. Section 28 further elaborates that RP is not authorized unless the prior permission is taken by the COC to dispose of or permit the disposal of shares of any shareholder, make any change in the management of the corporate debtor, transfer rights or financial debts, make changes in the appointment or terms of the contract of the personnel as specified in the committee of creditors, make changes in the appointment or terms of the contract of statutories. These all have been prescribed that the COC, without the approval of the COC, RP cannot do the transactions. Subsection 2 of section 28 specified that RP shall convene a meeting of the COC and seek the vote of creditors prior to taking of the actions as mentioned in subsection 1. Then no action under subsection 1 shall be approved. It means that at least a vote of 66% of the voting shares is required for approval of any of the transactions mentioned in subsection 1 of section 28. Where any action under subsection 1 is taken by the RP without seeking approval of the COC in the manner as required, such action will be outrightly termed as void. And the COC may report this action of the resolution professional under subsection 4 to the IBBI for taking necessary actions against him under this code. That will be tantamount as a disciplinary action. So RP should avoid, without the seeking approval of the COC, whatever the actions have been prescribed in subsection 1 of section 28. Now, one of the candidates has asked, what is the information memorandum? So section 29 deals with the preparation of the information memorandum. As we have already discussed, that RP shall prepare an information memorandum in such form and manner containing such relevant information as may be specified by the IBBI for formulating a resolution plan. And RP shall provide to the resolution applicant access to all the relevant information in physical and electronic form, provided such resolution applicant undertakes to comply with the provisions of the law, protect intellectual property, not to share relevant information, etc. So information memorandum, what we have discussed, that it is a information related to the company, and by having an idea of that information memorandum, a resolution applicant may make up a mind how to prepare a resolution plan and submit it to the RP and to the COC. By way of explanation, this section 29 elaborates that the relevant information means the information required by the RP to make the resolution plan for the corporate debtor shall include the financial position of the corporate debtor, all information related to the disputes by or against the corporate debtor, and any other matter pertaining to the corporate debtor as may be specified. Insertion of section 29A, need thereof. Section 29A was inserted by way of amendment, and this slide depicts about what was the need for insertion of section 29A. This section 29A was introduced in the IBC by way of Insolvency and Bankruptcy Amendment Ordinance 2017, which was issued in November 23, which later becomes an act. And thereafter, multiple amendments were made in section 29A. Before this this ordinance, any person could present a resolution plan for a CD that was subject to CIRP, irrespective of whether they were an original promoter, a director, or any person connected to them directly or indirectly. So what was the need of introduction of insertion of section 29A? a corporate debtor, suppose ABC Limited is undergoing a CIRP proceeding, and when the resolution professional has invited expression of interest, and the promoters or the ex-directors of that ABC Limited is also making the resolution plan. So Section 29A has outrightly debarred that persons from making the resolution plan. So in Section 29A, which is a elaborate section of this IBC, and this provides that these are the persons who can or cannot make the resolution applicant, cannot be a resolution applicant. So this Section 29A provides that the following persons are not eligible to be resolution applicant. Who are they? Number one, who is an undischarged insolvent, who is a willful defaulter. At the time of submission, if his account has been classified as an NPA, then further explanation, related party shall not include a financial entity regulated by financial sector regulator if it is a financial creditor of the corporate debtor and is a related party of the corporate debtor solely on account of conversion, substitution of debt into equity. That has been provided. Then explanation second, further, NPA, if the account of the resolution applicant has been classified as NPA, and shall not apply to such resolution applicant for a period of 3 years from the date of approval of such resolution plan. Then any person who has been convicted with an imprisonment for 2 years or more, for which act specified under the 12th schedule of this IBC, or 7 years or more under any law for the time being in force, who has been disqualified to act as director under the Companies Act, who has been prohibited by the SEBI from trading in the securities or accessing the securities market, or has been a promoter or in the management or control of a corporate debtor in which a preferential transaction, undervalued transaction, extortionate credit transaction, or fraudulent transactions has taken place. Then proviso of this Section 29A further provide that it shall not apply if a preferential transaction, undervalued transaction, extortionate credit transaction, or fraudulent transaction has taken prior to the acquisition of the corporate debtor by the resolution applicant. Thereafter, this subclause H has executed a guarantee in favor of the creditor. That person is also debarred from making a resolution to be treated as the resolution applicant. He cannot submit the resolution plan. He is subject to any disability corresponding to clause A to H under any law in a jurisdiction outside India. He is a connected person not eligible to under clause A to I. Then the meaning of the connected person has been defined by way of explanation 1. Further proviso details about the expression of the related party. It shall not include a financial entity. Similar provision has been provided. Then explanation 2. For the purpose of this section, financial entity means the following entities which meet such criteria or condition as the central government may, in consultation with the financial sector regulator, notify in this behalf, namely a scheduled bank, any entity by a foreign central bank or a securities market regulator, or other financial sector regulator of a jurisdiction outside India, which jurisdiction is compliant with the Financial Action Task Force FATF standards and is a signatory to the International Organization of Securities Commission's multilateral memorandum of understanding, and any investment vehicle registered with the foreign institutional investors. Then ARC registered with the SURF alternate investment fund registered with the SEBI, and such category of persons as may be notified by the central government. So section 29A debars the following persons who are not eligible to be the resolution applicants. Now come to the section 30, which describes about the submission of the resolution plan. So section 29A has already put aside some of the persons who cannot submit the resolution plan. So section 30 describes that who is eligible. It means except the persons mentioned in section 29A, all other persons are eligible to make a resolution plan. A resolution applicant may submit a resolution plan along with an affidavit stating that he is eligible under section 29A to the resolution professional prepared on the basis of the information memorandum. The resolution professional shall examine each resolution plan received by him to confirm that each resolution plan provides for payment of insolvency resolution process cost, then provides for payment of the debt through the operational creditors, amount to be paid to such creditors in the event of liquidation, and the amount that would have been paid to such creditors if the amount to be distributed under the resolution plan, which has been distributed in accordance with the order of priority under section 53, subsection 1, whichever is higher, and provides for payment of the debt of the financial creditors who do not go in favor of the resolution plan. And for removal of doubt, it is hereby clarified that distribution in accordance with the provisions of this clause shall be fair and equitable to such creditors. Further explanation 2 by way of Amendment Act 2019. This clause shall also apply to the CARP of a corporate debtor where resolution plan has not been approved or rejected by the adjudicating authority, where an appeal has been preferred, and where a legal proceeding has been initiated in any court, and provides for management of the affairs of the corporate debtor after approval of the resolution plan, implementation and supervision, and does not contravene any of the provision and conforms to such other requirement as may be specified by the IBBI. Then explanation provides that if any approval of the shareholders is required under the Companies Act or any other law for the time being in force for the implementation of the action under the resolution plan, such approval shall be deemed to have been given and it shall not be in contravention of that act or law. Resolution professional shall present to the committee of the creditors for its approval such resolution plans which conforms to the conditions referred to in subsection 2. The committee of creditors may approve a resolution plan by a vote of not less than 66% of the voting share. Then subsection 5 provides that resolution applicant may attend the meeting of the COC in which the resolution plan of the applicant is considered. It means the resolution applicant is also authorized to attend the meeting in which the resolution plan of that resolution applicant is being considered. But he is not entitled to vote in that meeting. So before we discuss about this case law, let us have again revised this section 30. That section 30 describes about the submission of resolution plan by the resolution applicant. So before submitting this resolution plan by the resolution applicant, he has to submit an affidavit that he is not debarred by the provisions of the section 29A. It means he is eligible to make the resolution plan, and whatever the legal compliances of making the resolution plan is required, that will be complied with. For example, for a combination or merger, certain regulatory requirements are sought by the competition under the Competition Act. So that regulatory requirement has been obtained or will be obtained by the CCI, and that will not be hindrance in the presentation of this resolution plan. So regulation, so this resolution plan, which the resolution applicant is submitted before the COC, that resolution applicant is having the right to attend such meeting. But in that meeting, that resolution applicant is not entitled to vote either in favor or against that plan. He can simply attend the meeting as an observer only. If the COC members consider that the resolution plan is according to the requirement, so what is the requirement? That the resolution plan is meeting out all the financial expenditure has been taken consideration of the financial aspects of the financial creditors, operational creditors, employees and workmen, and the resolution process cost, which has been incorporated. And whatever the favorable situation, whatever the resolution plans submitted before the COC, which is the best among the plans which have been come into the place before the COC, COC may consider it by a vote of not less than 66%. And this resolution plan will be put up before the NCLT for its final or formal approval of the plan. So this was all about the section 30. Now, in the Committee of Creditors of SR Steel, the Supreme Court has opined that COC is the supreme in the commercial matter relating to the CAR. Now, what the adjudicating authority is to see before approval of the resolution plan. Adjudicating authority is not to see or test the commercial wisdom of the COC. It is the COC who has to decide whether the resolution plan submitted by the resolution applicant is pursuant to the information memorandum, and it covers the entire resolution process cost. So the Supreme Court in this case opined that it must decide whether to rehabilitate the CD by accepting a resolution plan and the manner of resolution. What is left to the majority of the decision of the COC is the feasibility and viability of the resolution plan, which obviously takes into account all aspects of the plan, including the manner of distribution of realization under the resolution plan among the various classes and subclasses of the creditors. Section 31 deals with the approval of the resolution plan. When the COC approves with not less than 66% of the voting shares, the NCLT is satisfied that the resolution plan as approved by the COC meets the requirement. It may approve the resolution plan accordingly and may convey its decision to the COC. Where the NCLT is satisfied that the resolution plan does not conform, then it may by an order reject the resolution plan. When the resolution plan is rejected and there is no other alternative available, the adjudicating authority may order for the winding up or liquidation of the corporate debtor. This subsection 3 provides that when the order is made for the approval of plan, the moratorium which was imposed under section 14 shall cease to have effect, and the resolution plan professional shall forward all the reports relating to the conduct of the CIRP to the IBBI to be recorded on its database. And the resolution applicant shall, pursuant to the resolution plan, obtain the necessary approval required under any law for the time being in force. For example, as required under the Companies Act or as required under the other provisions, SEBI or Competition Act, within a period of 1 year from the date of approval of the resolution plan by the NCLT, or within such period as provided by the NCLT, whichever is later. In the Edelweiss Asset Reconstruction Company, the Supreme Court opined that IBC is a code by itself, and Section 238 providing overriding effect of it over the provisions of the other act, if any of the provisions of the act is in conflict with the provisions of the IBC. So a resolution plan may provide for the merger or consolidation of the CD with one or more persons in terms of Regulation 37(1)(c) of the CIRP regulation. Section 32, it deals with the matter of appeal. Means any appeal from an order approving the resolution plan shall be in the manner and on the grounds laid out in the Section 61, subsection 3. Means if any of the person is aggrieved with the order given by the NCLT, he may prefer an appeal before the appellate authority, and the time period is prescribed, that is within 30 days. And in exceptional cases, if the appellate authority is satisfied, it may provide a further period of grace of 15 days, that is up to 45 days. And grounds of the appeal are mentioned in the subsection 3 of Section 61. Section 32A deals with the provisions notwithstanding contrary contained in this act or code or any other law for the time being in force. The liability of the corporate debtor for an offense committed prior to the commencement of the CIRP shall cease, and the corporate debtor shall not be prosecuted for such an offense from the date of resolution plan has been approved by the adjudicating authority under Section 31. So there, before that, CD is not liable for that if the resolution plan results in the change of the management or control of the corporate debtor to a person who was not a promoter, or in the management or control of the corporate debtor, or a person with regard to whom the relevant investigation authority has, on the basis of material in its possession, reasons to believe that he had abetted or conspired for the commission of the offense. Now let us recapitulate on this Section 32A. Now a time frame has been provided under the regulation, that is a modal time frame. Just to have that commencement of the CIRP and appointment of the IRP T for today, then a model time frame has been prescribed in the regulation, that T, then T plus 3, then T plus 14. It means it provides a systematic time frame for each of the activity like that. We will share this slide so the students may have an idea about the broad model timeline for the CIRP right from the day of initiation of the CIRP till the date of the approval of the plan by the adjudicating authority and implementation thereof. This is the model time frame. And there are various forms has been prescribed which have been narrated in this slide. Have been prescribed in the rules also. Rules 2016 form 1 to 6, then under various forms prescribed under the regulations which are to be filed by the respective authorities. Now let us have revised whatever we have discussed today. To conclude the sessions, some 4 or 5 MCQs are there. So students, please make a note on their admin portal to mark their questions. So who declared the moratorium? Is it the resolution professional, the insolvency professional, the adjudicating authority, or the IBPA? The four options have been given. Who declares the moratorium? Yes, please. Let the answer come on this admin portal. Who declares the moratorium? It is the adjudicating authority. The reference says section 13 by 1 by A. The IRP is appointed by, who appoints a IRP? COC, resolution professional, IBPA, or adjudicating authority. The correct option is, as we have discussed, that IRP is an officer of the tribunal. So the appointing authority is the adjudicating authority. Moratorium period shall come to an end where adjudicating authority approves the resolution plan, where the adjudicating authority passes an order for liquidation of the corporate debtor, either of A or B, or fourth option is none of the above. And the correct answer is option C, either of A or B, when the adjudicating authority approves or orders for the liquidation. The IRP shall constitute committee of creditors, committee of debtors, committee of lenders, or committee of executives. We are repeatedly using the word COC. COC means committee of creditors. It is the answer. Correct answer is the committee of creditors. And the last one is the who is to conduct CIRP. Who is to conduct CIRP? IBPI, resolution professional, adjudicating authority, or committee of creditors. IBPI is the regulatory authority. Adjudicating authority is the fourth pillar. Committee of creditors and the resolution professional. And it is the correct answer is the resolution professional. So this was all of the CIRP proceedings we have discussed today from section 6 to section 32. And whatever the issues the students may face or might be having in their mind, may write the question in this admin portal. I will revert with the adequate answer. If you are not having the right question in your mind right now, you may write later on, either after some time or in the evening, or whatever the question you have relating to the, because this section 6 to section 32 is the main portion of the IBC which relates to the CIRP, and according to the syllabus prescribed by the ICAI also, this section 6 to 32 bears the main portion, and we will also discuss the liquidation part and the PPIRP procedure in the next session. So whatever we have discussed till now, you may raise any questions, and I will be happy to answer. So by these words, I thanks to each of the participants for patience learning, and thanks to Nisargji. With these words, I am concluding the session. Hello. Nisargji, I am concluding the session with these words. Okay.